Welcome back for another episode of the California Labor Law Odyssey. Showing you and telling you some of the most amazing stories of lawsuit abuse that you've ever heard. Going to curl your hair, get you mad, make you want to learn more and do something to protect your business. From the man who's been there and seen it all. Started an organization to fight all this. Tom Manza. Hey, Tom, how are you? All right, let's bring Tom in again there. There we go. Say hi, Tom.
Yep. Good morning, Paul. How are you?
I am stunned all the time that the stories that you come in here and tell people. I cannot believe that this whole thing is going on. We did the first 2 episodes last week of this new show, and we spent the whole hour talking about what? This PAGA thing. Just explain that in 5 seconds, 5 minutes, just so people understand. Each show we're going to keep reminding them what we're talking about here.
Yeah, well, again, my name's Tom Manza, and I'm with the California Business and Industrial Alliance. And I formed the organization specifically to try to reform some of California's labor laws, especially PAGA. And the biggest issue is it's difficult to explain it in 5 seconds.
It really is. It's hard to wrap here, but in essence,
it's a complicated law.
In essence, it stands for what?
They call it the Sue Your Boss Law.
Yeah, it really is. And PAGA stands for, the acronym stands for what?
Private Attorney General Act.
And as I get it, maybe I'm overstating this, it says basically that the state doesn't have enough regulators or enforcers to run around and check out if employees are being treated fairly under the labor law. So it basically allows the employee to be deputized, in effect, and to go sue not on just behalf of them or even a class, but of the entire state. You are suing on behalf of the state. If you notify them, I'm going to do this, if they don't stop you or say something, you are now empowered, and that gives you extra power to go investigate your employer and sue them.
Yeah, that's the attorney is the one who's actually enforcing California's labor laws. So you have trial lawyers enforcing California's labor laws, and that's where it's all going wrong.
And then, because the suit is on behalf of the state and you and whatever class comes together here, the state gets a big chunk of whatever the resolution is, along with the lawyer who gets a big chunk of it, which leaves very little for the actual plaintiffs, the so-called aggrieved parties here, right?
I keep going back to the same example, and that was Uber, and that was $7.75 million lawsuit settlement amount, 3.6 to the state, 2.6 to the attorneys, about $1 million to the people that were processing the paychecks and the paperwork, and each of the drivers got $1.08 each.
Wow.
So that should tell you
how skewed this thing is.
How skewed it is.
All right.
Absolutely.
So today you brought with you who?
I brought a very special guest, a good friend, a partner organization, Maryann Marino from Citizens Against Lawsuit Abuse. Welcome, Maryann.
Great to be here. Thank you for inviting me.
And what does your organization do? You similarly are outraged and upset against what?
Lawsuit abuse. We have more than 30,000 supporters in California. Most of us are all small business owners. And we take our message to the media and the legislature, and our message is simple. Give us relief from shakedown lawsuits, those lawsuits based on technical violations when no one is ever hurt. People are out there being sued $60,000 to $80,000 for not having a $40 sign? Really? This is what California wants to do to our business owners and our jobs?
And it really is that ridiculous. Give us some examples. You say that one again and a couple others. So it does feel like a shakedown. Some attorney comes in knowing that they discover that you have some small violation, and they're going to turn it into a major fine, a major lawsuit, millions of dollars perhaps, knowing that you can't afford to fight that, so you'll settle. And they profit from this. It's like a predatory group of attorneys that are roaming around trying to find these suits to throw up and collect a quick shakedown. It's like extortion, yeah.
It is extortion, and that roaming around has just brought an idea that I want to share. It kind of piggybacks on what Tom just talked about with the Uber lawsuit. Well, we have one of our supporters who's been with us maybe 20, 25 years, and he owns a small chain of restaurants in Los Angeles, and they're like in Burbank, Pasadena, West LA, and he wanted to expand his business, and he and his investors were looking at 7th Street downtown Los Angeles, because that's one of the new hip and happening streets, and he thought, great spot for my new restaurant. Well, while they were exploring, attorneys went and started trolling his employees to see, are you happy with your job? Is everything okay? How about your missed break? How about a lunch? Well, of course, one person said, well, I think I missed a lunch. And because he allegedly said that he missed a lunch, although all the documentation showed the payroll records that he took his lunch, that he signed documents that he took his lunch and everything else, just because he alleged that he didn't take a lunch, the business owner was subject to a lawsuit, a wage and hour, private attorney general lawsuit that cost him $700,000.
What? Unbelievable. And it cost him that much because the threat was what? We're going to sue for millions, because it's not just for this employee, it's for all your employees and for all your past and present employees, people you don't even remember you employed up back to a certain number of years, right?
That's right. And so the plaintiffs, all the ones that were supposedly hurt by this, all got $14. But they're not the only ones who lost, because the city of Los Angeles also lost. I was surprised when I learned that a restaurant employs somewhere about 100 people.
Sure.
So these were 100 people who would have had a job. The city of LA would have had more tax dollars. Instead, it was sucked out of the economy and given it to people who only go and prey on businesses to shake them down. They push real hard to force you to settle.
That's what's shocking. And I have some familiarity with this because, like you, several of you people in the room here, or others that you're going to bring in, I had a small bar and restaurant. Fortunately, it was 20 years ago in Mission Viejo. It was like an Irish pub. And it was there for 10 years until economics changed and we weren't able to keep going forward. But for that 10-year period, we lived in fear of ADA shakedowns or slip and fall shakedowns, where somebody would come in and say, "Oh, I got a piece of glass in my food," and then they'd put it in their pocket and go to the next restaurant and do the same thing. There were stories circulating among fellow restaurant owners of all sorts of shakedowns that people were being subjected to. You're giving me even more to worry about.
Well, I have one for you that also involved a restaurant owner right here in Newport Beach. And he shared how one day a patron came in and he had a little 7-pound white fluffy toy poodle. And he wanted this little 7-pound white fluffy toy poodle to have dinner with him and sit on top of the dinner table.
Okay, of course.
But the restaurant owner came over and said, "Sir, we'd love to give the dog a plate of food, but it would be better if we gave the dog the food outside."
Right.
Well, in this case, the patron, of course, took the dog, ran out, very mad, never went back, except 6 months later, the restaurant owner was served with a lawsuit saying that the dog was a service dog. And in this case,
my goodness.
The restaurant owner...
Yeah, lots of little fluffy white service dogs are running around, keep helping the blind or helping the needy here, yeah.
In this case, the restaurant owner knew he was right, and so he fought the lawsuit, and he won, but it cost him $100,000. So did he really win?
Yeah.
Wouldn't that money have been better invested in new jobs, new machinery?
What they used to call a Pyrrhic victory off of the old Roman battle, where they won the battle but lost so many people it was like they lost,
Hey, Paul, did you see the woman the other day that got escorted off the plane that had her service squirrel? Anybody see that?
No, come on.
Yes, she had her service squirrel.
Come on.
And apparently
a squirrel can't guide you around. And...
So they asked her to get off the plane, that the squirrel could not be on the plane because I guess they don't allow rodents. It was Frontier Airlines. So as they kick her off the plane, escort her off the plane with her service squirrel, she looks at everybody and she says, "Listen, I'm out for blood now. I'm going to sue this airlines, and I'm going to own a big chunk of it."
This is now going to be my airline here, yeah.
Right. But, I mean, to me, that is just the big issue is, unfortunately, people like that, an attorney will file a lawsuit, and they will shake down Frontier Airlines over it.
Because
and
they
will
assume
cost
you
them money.
can't, it's cheaper to settle than it is to fight.
It's too easy to sue people, especially in the state of California.
Mm-hmm.
And it's too expensive, the potential to fight it, right?
Yeah.
Like even the case you said, the guy said, "I'm not going to give up. This is ridiculous. Your fluffy white poodle can't sit. It's my restaurant. I have the right to refuse you anyway. And I did so politely. It's a dumb idea. I'm not going to do it. I'm in the right. And there, I'm going to prove it." But I had to put $100,000 on the line to prove it. That's ridiculous.
It's all about the money, too. I'm sure nobody ever came back and checked to see if the service dog could come in or any other service dogs come in. That's the thing with these ADA lawsuits or any of these other kind of lawsuits, as a matter of fact. Nobody ever comes in to really see if the alleged technical violation was ever corrected. It's all about the money.
Well, again, these are apocryphal stories. These are I can't prove any of these, but these are just tales I heard as a restaurant owner. That at one time back in, this is 20, 30 years ago, there was an attorney, and I think he was in a wheelchair, and he figured out that he could make a lot of money simply by rolling into restaurants all over town and finding what were these are restaurants that had passed ADA compliance, that had tried to be good corporate citizens, that had all the permits in place and had all the stuff checked, but he'd find some little minor variation that somebody had missed, and then he would immediately come and threaten you with a big lawsuit, and everybody would say, go away. Here. Okay. One, they didn't want the publicity, and two, they didn't want to go hire attorneys. So it was often cheaper to pay somebody than it was to, and he knew this, and he profited from it. I don't know if that story's true or not, but that's the kind of horror story that we live in fear of. I certainly know there are people that practice slip and fall, con artists that go from store to store and pretend they fell, and knowing that you'll give them $10,000 just to go away. I know examples of that. So again, we live in a society where there are a group of people who will find any of these laws put into place and try and find ways to abuse them for their own personal gain, right?
Well, that's what it's all about. We call it the cycle of lawsuit abuse because, you know, these people, they're very creative and they want to make sure that their way of shakedown lawsuits and shaking down businesses for unwarranted lawsuits continues. So they go and they fund legislators. They give to their campaigns. So the legislators go and writes bills. The governor signs them into law that are just nothing but new regulations. And unless you have a staff of 50 to keep on top of all these regulations, one way or the other, you're going to be sued because you're not in technical compliance. These are businesses that are doing good work. They're stellar companies. They have good jobs, but they're subject to this kind of abuse. And what happens? If they have to settle, they have to cut jobs.
And the shocking thing for me, to talk about this, Tom, a little bit, the minutia, the minor things that turn into major bucks. Give me some examples of minor violations that you've seen turn into major settlements here.
Well, I mean, if you just take, for example, the restaurant industry. If you think about the restaurant industry, if you think about how it really works. I mean, if you're a waitress and you're working and you're putting in an 8-hour shift and you're in the middle of a table of 12 people and you've been working well with them and you know you're going to get a pretty good tip, they're happy with you. And then you realize, well, wait a minute, it's
break time.
4 hours and 59 minutes, and I haven't taken my lunch yet. I better take lunch. Is she supposed to say, I'm sorry, someone else is going to have to take care of you now because I have to go take my lunch?
Yeah.
I don't think that's really fair. So
but that happens. I see it happen all the time.
That's what happens. So somebody will, you know, take a late lunch, and one person taking a late lunch can go seek that attorney, and then the attorney will say, well, let me take a look at your paycheck stub. Is the right week ending date on it? Is the right name of the company on it?
That's the stuff
that
gets me.
Information on there.
And any and all of that can trigger one of these lawsuits.
Well,
a minor mistake in the paycheck stub seems to be a major red flag for these attorneys.
It opens the door for them to search. So what they
because once they're empowered by the state to file this lawsuit, that gives them what, extra power to go back and look through your records?
Correct. So let's just say that you've got 100 employees, and out of those 100 employees, 90% of them are making way above minimum wage.
Okay.
But let's say you only have 2 or 3 that are making minimum wage. They're brand new. You just hired them. And those folks, if something was off technically and you owed them an hour's worth of pay because they took a late lunch, right? One little glitch.
Right.
Then that means that their paycheck was inaccurate. Their paycheck would be so inaccurate that they would be making under minimum wage. So once they're under minimum wage, then what they have is they file another one that would be a unfair competition. So then that
because you're hiring people at lower than the prevailing wages here,
right? And then that rolls the whole lawsuit back instead of 1 to 4 years.
All right, give me some other examples. Maryann was throwing a couple out. Little petty, little picky things that they find to threaten you with a major lawsuit.
Well, I'll never forget the day on the steps of the state capitol when our Citizens Against Lawsuit Abuse supporters were up there advocating for reform. And one of our supporters stepped forward, and he was a little older. His hands were cut, obviously, from hard work, a little hunched. And he shared that it didn't matter that he paid his employees, on time, or that the check cleared the bank. What mattered is that the check stub didn't have a beginning date or an ending date. So he was sued for a class action status for every employee, for every pay period, for 4 years.
Because he didn't have a start and stop date. It didn't define what this paycheck is covering here in writing. They all knew. He knew.
They got their money.
Yeah.
I mean, it seems to me if somebody didn't get their money,
no one was harmed.
Nobody was harmed.
Right.
But you know, that business and those jobs, they're not in California anymore. They're all in Texas.
So is this just a California problem, or is this a nationwide, we live in a litigious society where everybody's first reaction is, I'll sue you?
California is the only state with PAGA. And California's been ranked like #1 for judicial hellholes is what they refer to it as.
Okay. All right.
I think Florida got first place last year,
right?
You know, but prior to that, I think California's made it 5 years in a row.
And who were the politicians that came up with this notion? It must have been somebody that said there is abuse happening, we can't enforce it, so we're going to deputize ordinary citizens to go sue their boss.
Well, you know, this was a good bill. It was very noble, and it was put into place back in 2004. And what it was to do was to protect employees from bad employers.
Right.
Those
Clearly.
employers, right, who were here maybe 1 week but not the next. Those employers who didn't pay their employees for all the hours that they worked. Those employers who maybe paid with hot checks. Well, absolutely. That's wrong. We agree. You know, you should go back and sue them. But certainly not because somebody doesn't have their vacation hours on a paycheck, their sick hours on a paycheck, the beginning date or the ending date, or any other kind of technical violation that they can come up with to stack and file a lawsuit against business.
We've had some big labor attorneys in here through the years. There's a big firm right down the street from us here and a couple others around. And these are firms that primarily defend businesses. And they've said, watch out, there's 2 or 3 hot ones that every shady attorney will immediately ask their clients for, knowing that they're easy targets and easy money. One of them seems to be lunches. Talk about that. This idea that after you're a minute late in lunch, taking a lunch, even if it was you, like in the waitress example, saying, I'll put it off for 5 minutes. Sorry, you've created a violation for that business that opens the door to major lawsuits, right?
Well, a lot of times it's hard to prove. I mean, you have to think about everybody's type of job. So let's say that you own a landscaping company.
Yeah, right.
Right? And if you have people out there mowing lawns and things like that, you have to trust they're going to go take their lunch.
Because there's no supervisor on site to say stop.
Where
right?
are they going to punch out? So now they come up with ideas. Well, there's an app. You can put an app on your phone, and then they can punch out on the phone. Now the problem is because they're using their phone, you know, what if are we paying the expense for that phone? There's been lawsuits where people have been filed for answering an email after hours, and they should have been paid for that.
Yeah, right.
So it's such a tricky road. I mean, you have 1,400 pages in that labor law digest. How do you keep track of what's going on?
And how do you, as a business owner, even if you want to comply, do so to the absolute letter of the law? And even if you do, how do you prove it later, like you're saying with the landscapers example?
I mean, I'll give you one other quick example.
Yeah,
just
so
to
we're
show
looking
you
for some
how ridiculous it is. So there's a company in Bakersfield that had a great thing going. Everybody was happy. They would show up to work. You know, if their punch-in time was 6 o'clock, they all got there early because they'd be out in the oil fields, and they would ice up to get their ice in their pickup truck, and they'd all hang out in the parking lot and talk about, hey, what happened the night before? How was your kid's baseball game?
Sure.
Maybe they would wipe down the trucks, and then they would be off to work. Well, you know, guess what happened? PAGA lawsuit. Those guys sitting there loading their truck up, getting it ready, they should have been paid for that.
Wow.
I mean, this was camaraderie that got ruined. And the owner had to tell them, I'm sorry, you punch in, then you go to the parking lot. And then when you're done with the day, you punch out and you go home. You can't hang around here anymore.
No.
Well, there's even one now against the coffee shops where the gentleman wanted to go and escort after work, after they punched out, the female employees to their cars to make sure that they were safe. Well, because he punched out and he was spending time, walking them to their cars, he felt that he should have been paid for that. So, we're going to have to see what happens to that.
Wasn't that a big chain or something? You talked about that the last one.
Yeah, Starbucks.
Starbucks. Wow. Okay. So, give me some other things. We've talked about lunches. And in your case, just summarize your case again here, Tom, that got you so fired. It seems if you get stung, that's when you get outraged. Until then, you're either dumb or don't want to know.
If you ask people, if you ask business owners, you say, hey, are you familiar with PAGA? Do you know what it is?
No.
They say no. And if they say yes, they've been sued.
It's that simple.
It's that simple.
Right.
It's that simple. So our company always had a flexible work schedule. People could come in at 5, 5:30, 6, 6:30, 7. Unusual for manufacturing, but, our goal was just to make sure we got the job done. And we had a small safety incentive. People stay safe, we give you a little bonus. So what happened was we had employees that took their lunches later than 5 hours. We didn't even keep track. People did not punch in or punch out for their lunches, which was another problem.
And you talked about a lot of these employees had been there for decades, years and years and years. And so as
average is 25 years. We've got some 38.
So as they started coming in at flexible hours, they still wanted to eat together.
Yeah, with their friends, with their spouses, with their relatives. And it cost the company $1 million.
$1 million you had to settle because trying to do a good thing, let them have a flexible schedule and let them decide when to take their lunch and with whom, rather than forcing them each one by one. Sorry, you got to go take your lunch right now because you came in 30 minutes or an hour before the rest of the crew did.
Right.
And that was, and the settlement came because of what? I mean, was somebody filed a PAGA lawsuit?
Well, they're all settled. And the people that do end up fighting them, they spend millions and millions of dollars. And sometimes, the judges will go in their favor. Sometimes they won't go in their favor. So I would say 98% of the PAGA lawsuit cases are settlements.
And you made a point that I thought is worth repeating here. Many of these attorneys are banking that you're not going to go there. They don't have the resources themselves. Or they are predatory. They're just trying to come in and threaten you with a big number and hope that you'll settle and go away. They do almost nothing other than write the letter. Right?
Well, for anybody listening, this is how they look at it. Okay? There's not a whole lot of intelligence that goes into dissecting it. They figure out everything you did wrong, and they add all of these fines and penalties.
What they think the maximum could be.
But the bottom line is you're probably looking at $75,000 per employee.
Oh,
so if you've got a wage and hour lawsuit or a PAGA lawsuit, that's what you need to budget.
I don't even know how to respond to that. And how many of how many small businesses do you think there are in Southern California or in California?
I don't know, Maryann, you probably would know that stat, huh?
Well, I want to say millions. I don't really know the stat.
I'm just trying to figure out.
I think there's a total of like 900,000 in the
Is that what it is?
Yeah.
Okay.
I'm trying to figure out the potential pool of targets here. So let's say
there's a big one.
Let's say there's 1 million small to mid-sized businesses here in Southern California. I'm not talking about, some giant corporation. I'm talking about average to large businesses, small to mid-size, right? How many of those do you think are vulnerable to these types of attacks?
Everybody.
And they probably prey on those because those businesses are busy running their business and being in business and being the job creators that they were meant to be. They're not to be examining legislation and regulations to see what they're in compliance with or not. They don't have the money to do that. But these guys who go and sue them, they know that they don't have the money to litigate, and they go and they zero in on them because they know that they would be easy to settle. And they do focus on small business owners and mostly minority small business owners as well.
Really? Why would minority? Because they assume that they know less about the law or something, or
they're just very easy to settle.
Absolutely.
Mm-hmm.
They're fearful. They're more fearful and willing to cough up money quicker here.
When I came here, I got here a little bit early, and I had to use the restroom.
Oh, Tom, don't go there, please. Yes, go ahead. I know you did this the last time.
Yes. So It was a little bit cold in there. It was a little chilly.
Was it a little too cold for you?
Yeah,
Okay.
and I don't know if people realize that the restroom needs to be above 68 degrees.
Oh, come on, Tom.
If not, it's a labor law violation.
Oh, come on, Tom. And somebody could come and sue because my restroom was too cold?
Yes. So, and that's in the 1,400-page labor law digest. So be prepared.
Give me some other ridiculous examples like that. Paycheck, you talked about pay stub, a lot of pay stub violations, wrong date, wrong hours, wrong something, minor calculation. You can't just correct it. You're going to have to pay for that.
Yeah, there's just so many technicalities, commission agreements, how do you calculate incentives. Lunch, I'll give you another example. We always had a safety lunch every quarter. We brought in the taco guy, and man, it was wonderful. I mean, we took a long lunch, sometimes an hour and 20 minutes, and everybody hanging out and talking. But the cost of that lunch, now we calculated it out per person, and that needed to be added into their overtime rate.
Wow.
So we didn't get penalized.
And you gave another what seemed to me a ridiculous example in your own case. Little safety award, what, $100 or something, or some minor amount of money you give them once a year if they don't get in trouble. And
our calculation was off pennies.
And so, therefore, that's supposed to be part of their pay. That wasn't just. How do you describe it? That was a.
And they actually changed the flat rate bonus. A wonderful
flat
judge
rate
did this.
bonus. That's what it is.
That's what they call it. They changed it this year because there was a case against Dart Container, and the judge was so nice. He said that, okay, this can go back 3 years too. By the way, this is a retroactive. Think about that.
Yeah.
So if you were calculating anything, any kind of flat rate bonus, you could have a big problem on your hands.
And the idea is if you miscalculated it by pennies, the payroll stubs for all these people are now wrong.
Correct.
By pennies.
Correct.
And therefore, they can all come back and sue. And the suit isn't just for the pennies that they missed. The suit is all the penalties and all the other things that because somebody's attorneys want money. Administrators want money. The state wants money.
Well, you know what?
Everybody wants money.
Let's see if I think you know from our last show, but Maryann, what happens to the employee, the past employee? What's the penalty on him, the one that no longer works for the company?
Well, see, that's the thing with these type of.
You know what it is?
No, I was going to say a lot of these. Go ahead, tell me.
Do you remember, Paul? What happens? You owe them,
I don't want to remember any of this. This is like a nightmare. No, I don't remember.
You owe them 30 days' pay because their paycheck was wrong.
Oh, wow, for pennies.
That's right. Pennies, an error.
You're off pennies, and your past employees, you owe them 30 days' pay.
Wow. Well, I got to take. I really need 30 minutes to recover, but we're going to take 2 or 3 and try and figure all this out. And then we're going to come back and see if there's any hope to this hopeless situation, this bleak, dark assessment that you're giving me, and the potential for all of us to be sued. Right after this.
I'm on the observation deck of the Empire State Building to demonstrate how much material Waste Management recycles. As North America's largest residential recycler, last year alone, Waste Management recycled 12.9 million tons. How much is that? Let's do the math. Carry the 6. It's enough to fill this building more than 27 times. With experience like that, we're bound to have a program that can help your business recycle. Talk to Waste Management or visit thinkgreen.com.
When you use the Premier Rewards Gold Card from American Express, the rewards points can keep on multiplying. Buy 3 with triple points on airfare. Buy 2 with double points on gas and groceries. And a single point for pretty much every other dollar you spend on the card. Then, start choosing from over 1 million rewards to redeem all those points. Apply today and the annual fee for the first year is on us. Call 1-800-AXP-GOLD or visit AXPGold.com. The annual fee for the card is $175. See terms, conditions, and restrictions at AXPGold.com.
All right, we're back with Tom Manza and the, give us the organization again. I don't want to mispronounce it here.
California Business and Industrial Alliance, CABIA.
CABIA. I know it's CABIA. I always forget what the acronym goes for. And you were here with Maryann, and her organization is?
Citizens Against Lawsuit Abuse.
How did you two find each other and come together, and where do you overlap and where do you not? Tom's focused on one specific area, which is the PAGA, this Private Attorney General Act. I'm assuming is a wider net of potential lawsuit abuse, right?
Right, lawsuit abuse. Well, one day I was reading the Orange County Register, as I always do, and Tom always has his op-eds, published by newspapers across the state.
Been very good about that, right?
Yes, he has, and I happened to see the one in the Orange County Register, so I reached out and I left a message. I think it was a half a second later he called back. And
he's fired up about this, yeah, because he's been burned, he's been stung, yeah.
That's right. And so we met and we began educating legislators as well as other business owners.
And what was your motivation? Why did this resonate with you?
Well, I grew up in a family business, and so I know how hard it is to start a business and how that business runs you. You don't really run it because it's kind of all the time.
All consuming, yeah. When I had a restaurant, it was 24/7. Things break, things burst, things happen.
That's right. And at the end of the day, it's you and you've got to make it happen. And it's almost impossible anymore. It's a lot worse. I don't know how a business can really start today and be in business. If you didn't start a long time ago, it would be very hard to start a new business today. But
because you can't just, for example, owning a restaurant, we thought it'd be fun. It'd be like Cheers. A bunch of us came together. We'll put in some money. We'll have a little private watering hole and a fun place to go hang out with our friends and family. Wouldn't this be fun? And no, it wasn't fun at all, because the number of regulations we had to go through. We had to go through alcohol and firearms and tobacco. We had to get a liquor license and go through that. We had to be in compliance with all the rules and regulations of building a business, like the Americans with Disabilities Act and many others. We had to go to the health department. I'll give you a silly example. We went to the health department, and our designer came in back in the kitchen and said, "Why don't you put this kind of gritty tile down so that nobody will slip?" Because water, it's a kitchen. Water gets splashed, and people slip, and they slip and fall. Oh, okay, we've never done this. That sounds reasonable. Except we didn't go clear it with the health department beforehand. So the health inspector comes in and says, "What's this?" So it's a gritty tile. Aren't we good people? No, it's not an approved tile. Rip it out. What do you mean rip it out? We had to rip out the whole tile. It was thousands and thousands of dollars because it wasn't on the approved tile list. Stuff like that I learned the hard way. There is no fighting it. When we built a bar, I'll give you a silly example. We built a 30-foot-long bar, and everybody said, "Oh, this would be a spectacular showpiece. Everybody want to sit at the bar." We went to the city of Mission Viejo, and the inspector came out, sorry, Mission Viejo, and he said, he looked at the ADA Act, and it says, all bars shall be handicap accessible, or something like that. I forgot the exact wording of the rule. And he thought that meant not the bar, the business, but the physical bar that we were building. So he wanted the bar itself to be 30 inches tall. I said, we're going to have a 30-foot-long, 30-inch tall bar. 24-inch tall bar, whatever it was. I said, this will look like it's for, little people here. This is crazy. And we had to fight and get attorneys and all this stuff, and they said, okay, only one. The reality is only one little small section somebody has to be able to roll up and sit in a wheelchair, not the entire 30-foot-long bar. Insane stuff like that. Insane stuff. And that plus the difficulty of running a small business today burned us out. We quit. Give up. Out of it. So I think that sort of stuff happens. Is there any hope? Is there any way out of this black nightmare are we all just sitting here praying that they eat the next guy and not me? Is it the minnow school of survival? If there are enough small fish swimming around, the shark can't eat all of us?
Well, there is hope. I mean, because of groups like CABIA and Citizens Against Lawsuit Abuse and all our supporters that take the time to share their message with legislators and let them know the harm that a lawsuit has done on their business and the jobs that they created. So when they go and vote, they remember these stories and these faces, and they vote for bills that favor civil justice reform over those that do not. There is hope with the ADA after 20 long years that there will be federal legislation sponsored by Congressman Ted Poe out of Texas to correct the whole problem.
Because, again, I want to be the first to state, I think the Americans with Disabilities Act was an applaudable idea to get rid of these small barriers that seem like mountains to somebody in a wheelchair. My mother was in a wheelchair the last couple of years of her life, and I didn't realize how big that little threshold was to her. It kept her from going all sorts of places. So I applaud the idea of it. But what's the penalty if you're in violation of it? It should be corrected. It should be, and maybe if it's a egregious enough one, a little more than a slap on the wrist. But it's not an atomic bomb. And that's what we seem to be dealing with now. What's the penalty if you are found to not be in compliance, either through ignorance or through laziness, or maybe you were just trying to cut corners and hope that nobody would catch you. But what is that penalty? Is it to correct it and give the employee back their 14 cents and correct the paperwork and fix the threshold barrier or whatever it is that was causing the problem? Or is it to simply create a atomic bomb reaction that attorneys can use against you to extort money from you?
It's all about the money. It's not about the access. Everybody wholeheartedly agrees. My dad was in a wheelchair too, that the disabled should have access to public places. But certainly, if something isn't compliant, the blue striping on the parking lot or the right sign isn't out there, or
Fix
the bathroom mirrors, give them time to fix it. Give them 120 days. If they don't do it, then maybe you better take a little bit more extreme action. We agree, but it's anywhere between $1,000 to $4,000 per each issue for technical noncompliance. So if your parking lot isn't right, if your walkway is too wide, if your bathroom mirror is too high,
or too cold,
that could be $12,000. And so you're forced to settle for that $10,000 or $12,000 just to make it go away. Nobody really comes back to see if you ever got the right parking lot sign.
And when you settle, it doesn't go to the plaintiff. It doesn't. Not only does it not mean the problem gets fixed. I suppose it gets fixed because you want to get sued again. But the purpose of the law was there to prevent, to provide safety, and to provide employees protection. How does it protect them if the attorneys and the administrators in the state take all the money or most of the money?
Well, it doesn't. And that's what the abuse is that it's all about the money, not about the access. You never get somebody to come back and give you a sticker or put some sign on the wall that says you're in compliance or that you corrected these actions. As a matter of fact, we have motel owners in Norwalk who were all on the same street. They were all sued under ADA, and they were all going through all the different things they had to do to correct the things that they had to do to be in compliance. Well, as you know, when you go and you undertake some of these big projects, you don't do them all at the same time. You've got to kind of do them one by one.
Phase them in, right.
Phase them in. Well, here they were, they had 8 out of the 10 things they had to do to correct to be in compliance. Well, they were doing it, but then they got sued again for the 2 that they were still needing to work on. So that's just not right. You are sued not once, but you could be sued twice, 3 times, or more for the same thing.
And nowadays, from what I understand on the ADA, is that a lot of the attorneys, they don't even need to send in the fake guy to find the problem. They can go on Google Maps and look at it, and that's what they're doing.
That's what they're doing. There's so many. I mean, there's so many federal laws, so many state laws. Nobody really knows what to be in complete compliance.
So you're saying there are attorneys that are literally trolling employees, saying, let's go make some money this week. Let's find some employees.
That's absolutely what they're doing.
Or they're trolling the internet, saying, where can we find somebody in where can we find a technical violation that we can shake them down?
And I think what's the real issue, the root of the real problem here is I think business now has become like the evil empire.
Yeah.
Everyone thinks that these
Well, I look at you guys, you both look pretty evil, so I just
they all think businesses just have tons of money and we're out to get every employee, and that's not reality. You look at some of these, again, back to the restaurant owners. Somebody owns a small restaurant, they employ 10, 15 people. They get hit with a wage an hour and ADA. They cannot afford it. They are going to go out of business. There's no doubt about it. It is impossible for them to make ends meet after something like that happens.
So give me some hope as we wrap up in the last 10 minutes of the show here. Not just joining organizations. Are there bills being pushed through to correct any of this or to bring it back into balance?
We're definitely going to be working on a bill, and I think that the main thing is it's a lot of education, and we've had some meetings where...
And what is the education? Just this can happen to you?
Things to look out for. Look at your paycheck stub. Here's 10 items that'll keep you somewhat safe.
Is there a template? Is there a checklist on your website or any place people can go to start evaluating without hiring a compliance attorney or a compliance consultant?
I don't have that, but that's a
good idea.
See.
Well, you're hired.
Well, because I think that if you want to educate, and then immediately I want to go to the internet and look at some things, some checklists,
Well, I actually on our website we do have the True Up calculator, an Excel spreadsheet.
It's a what? It's a what?
True up if you're giving somebody a flat rate bonus, so you calculate it correctly to make sure.
Well,
you do.
I'd encourage you guys to come up with more of those kind of templates and checklists that we can send people to. Must be consultants that you can hire for a bunch of money that'll go through this and proactively search through your list of potential compliances?
There are, but there's some issues with that, because again, when you have a 1,400-page labor law digest, it's very complex and there's a lot of misnomers out there, and it has. I've heard the stories and seen the stories, and it's not good.
Any other actions, Maryann, that you want people to join your organization? Does it cost money to join the organization? Is it free? How does it work?
We are a free supporter-based organization, and there's nothing stronger than a small business owner or concerned citizen sharing their story with their area legislator to let them know about the experience that lawsuit brought to them, to their business, to their family, to the jobs that they create. There's no stronger voice than that person. So we would encourage you to go to our website, www.cala.com, and become one of our supporters, or you could email me at mmarino, MMARINO, at cala.com.
cala.com. All right. And from your standpoint, other than, is it just an education point? Do you got to get more people enraged and mad about this before you can move any bills through or move any reforms through? Is this a question of not enough people know about it or want to know about it?
Well, the legislators need to know about it because Election Day is November 6th, and so I would assume that there will be a lot of new legislators that will need to be up to speed on some of these laws that are impacting their business owners. So now is the best time to get involved so you can share your story with legislators before the new legislative session comes and they start voting the wrong way that'll impact your business.
But can I give you, I don't mean to give one more depressing thought here, but we've had lots and lots of local politicians, left and right, Democrats and Republicans, and even some independents through this studio in the last couple of months, as you can imagine, all making their case for, stay the course or change your legislator. And I haven't heard one of them, not one of them, talk about lawsuit abuse. They talk about other sorts of regulations. They talk about environmental regulations or other sorts of things, yes or no, good or bad. But I don't hear anybody touting your cause here. Is it just a question of they're not aware of it? Is it a question of there aren't enough people enraged and coming? It seems like you get enough people enraged about anything.
I would say it's both. I think there's not enough people aware of it, and I think that not enough people have come to the fore. A lot of people are afraid to speak out.
That's what I was getting at, because if you've been stung, I think I'd be afraid to raise my hand to tell anybody about it for fear they'd hit me again.
There's people that have been sued 2 and 3 times.
Yeah, I think you got one coming up on your next show here. Well, all of that is fascinating. Again, any other thoughts? Maybe we'll get some checklists and some to-do lists up on your websites. People can start there. How else can people get educated about this? Nobody's going to read a 1,400-page labor law section of the code or the law here to try and, or much less understand it or interpret it. Should you contact your attorney? Should you contact who? Who would I go to? Who's going to tell me whether I'm in compliance?
Well, if you go to Maryann, she'll probably pass them over to me, and you can have them call me, right? So.
And do you have people that can come and do an audit? Let's say.
Yeah, we do have a group of attorneys that we've went through and we've kind of found, because there's a lot of attorneys out there, but there's not as many that specialize in these kind of labor laws. There really isn't.
So most business owners are probably going through this alone or on their own, or with an attorney, just a regular general business attorney who may or may not understand the complexities of this law.
Correct.
Not as well as their adversary who looks for these violations and profits from them.
I'll give you one quick example. There's a very large restaurant group, and they have chains all over the United States.
Okay.
They have 50 human resources people on staff.
50? Wow.
Three attorneys that work directly for them, and 3 of their locations got PAGA lawsuits in California.
Wow.
And California is the only one with PAGA lawsuits, so they don't deal with it anywhere else but California.
Well, they're going to be more educated now, as is everybody listening to this podcast. Give us, again, some places, some websites we can go if we've gotten you scared and maybe a little motivated to dig deeper into this. Where do they start with you guys?
Go to www.cabia.org.
And the other one?
www.cala.com.
Okay. And how many people, roughly, how big is these organizations? Dare we say, are you still small? Are you growing? Have you got a large constituency behind you now here?
Well, CALA has about 30,000 supporters,
Wow.
most of whom are small business owners.
Wow, pretty impressive.
And we've got about 100 members now.
Because yours is a paid membership for businesses
Correct.
to get behind, and
Right.
because you're trying to fund actual attorneys and you're trying to fund
lobbyists,
yeah.
ad campaigns. And
Yeah, okay. Well, congratulations to both you guys. I'm just shocked and stunned when I hear this, scared a little bit as a small owner myself, and hoping that what you're saying can't be that bad. It can't be. Please, God, tell me it's not as bad as I think it is, but I think it's even worse. So thanks for coming in. We'll keep informing everybody and rallying you to the cause here, right on the California Labor Law Odyssey.